everybody, ready to continue the journey into the electronic funds transfers FAQs? We're going to skip the intro video this time. We've covered questions 1 and 2 in the last class, but again note, I'm taking this information straight from the FAQ. But like always, I'm going to throw in my own thoughts and my own opinions and the professor's oversimplified view. There again will be a final class in the series that will wrap up everything with some key takeaways. For now, as always, do make note that I am not an attorney and this is not legal advice. Those kind of questions, they need to be answered by your own legal counsel. And that's because every situation can be a little bit different. Moving along now to question number 3. Can a financial institution consider a consumer's negligence when determining liability for unauthorized electronic funds transfers under Regualtion E? Or to put it another way, if I just didn't know any better, is it my fault? Okay, that is really putting the question into a very loose, Payments Professor oversimplified interpretation. But I gotta tell you, the answer is still gonna be no.
No!
Regualtion E sets forth the conditions in which consumers may be held liable. That's may be held liable for unauthorized transfers. And its commentary expressly states that negligence by the consumer cannot be used as the basis for imposing greater liability than is permissible under Regualtion E. You want to look that one up yourself? You can find it here. And the example that is given is that consumer behavior that may constitute negligence under state law, such as situations where the consumer wrote the PIN on a debit card or on a piece of paper and kept it with the card. Don't do that. But if they did do that, it does not affect the consumer's liability for unauthorized transfers under Regualtion E. Here's that comment. Let's move on to question number 4. If a financial institution's agreement with the consumer includes a provision that modifies or waives certain protections that are granted by Regualtion E, such as waiving Regualtion E liability protections if a consumer has shared account information with a third party, can the institution rely on its agreement when determining whether the electronic funds transfers were unauthorized and whether related liability protections apply? That's a really good question. And it's a complicated question, so let's put it this way. Can a bank get out of liability by an agreement? I can't simplify it even more than that. And the answer is going to be no.
No!
Yes, yet again, the answer is no. The Electronic Funds Transfer Act includes an anti-waiver provision stating that no writing or other agreement between a consumer and any other person may contain any provision which constitutes a waiver of any right conferred or a cause of action created by EFTA. But there could be circumstances where a consumer has provided actual authority to a third party under Regualtion E according to, well, it's 12 CFR 105.2M. But an agreement cannot restrict a consumer's rights beyond what is provided in the law. And any contract or agreement attempting to do so, that's a violation of EFTA. So in other words, you can't create an agreement that goes beyond Reg E protections and use that as your way out of liability if you're the financial institution or organization involved in this one. That's how it works. Let's move on to question number 5. If a private network rules provide less consumer protection than federal law, can a financial institution rely on private network rules? Or let's look at it this way. Can the rules for something like Zelle or ACH or any other way of sending money electronically be used in place of Regualtion E and hold me liable for the payments I normally would have had protection for? The answer is no.
No!
Although private network rules and other agreements may provide additional consumer protections beyond Reg E, like you can give me more protection than Reg E does, that's fine. less protective rules do not change a financial institution's Regulation E obligations. You just can't do it. Want an example? Here you go. Some network rules require consumers to provide notice of an error within 60 days of the date of the transaction, even though Regulation E allows consumers to provide notice within 60 days after the institution sends the periodic statement showing the unauthorized electronic funds transfers. Other network rules allow a financial institution to require a consumer to contact the merchant before initiating an error investigation, even though we see that triggers the error investigation obligations upon notice from the consumer. We got a no to saying it was customer negligence, a no to using your agreement to undermine Reg E, and a no to using the payments network rules to be able to supersede Reg E. What I would say yes to is hitting that subscribe button, as we still have some questions from the FAQ to review. For now, class dismissed.